Interpleader is civil procedure that allows a plaintiff to initiate a lawsuit in order to compel two or more other parties to litigate a dispute. An interpleader action originates when the plaintiff holds property on behalf of another, but does not know to whom the property should be transferred. It is often used to resolve disputes arising under insurance contracts. Usage: in an interpleader action, the party initiating the litigation, normally the plaintiff, is termed the stakeholder. The money or other property in controversy is called the res. All defendants having a possible interest in the subject matter of the case are called claimants. In some jurisdictions, the plaintiff is referred to as the plaintiff in interpleader and each claimant a claimant in interpleader. An interpleader proceeding has two stages. The first stage determines if the stakeholder is entitled to an interpleader and if he should be discharged from liability. The second stage is like an action at law to determine which of the claimants is entitled to the res. Application: for example, suppose a person dies with a life insurance policy. However, the insurance company knows there will be a dispute over who should receive the proceeds. The insurance company can file an interpleader action. The insurance company is the stakeholder, the claimants are the persons who might be beneficiaries under the policy, and the cash value of the policy benefit is the res. Under the proceeding as originally developed, the stakeholder would deposit the res with the court, and then the defendants would have their claims adjudicated by the court. Statutory modifications to the procedure, which vary by jurisdiction, sometimes allow the stakeholder to retain the res pending final disposition of the case. Typically, once the stakeholder deposits the res into the court, the stakeholder is released from the action and the claimants proceed against each other to determine which of them is legally entitled to the res. A disinterested stakeholder is entitled to costs including attorney's fees. Except for the denominations of the parties, the action proceeds for the most part as other civil lawsuits in the same jurisdiction. In some jurisdictions, the res will earn interest at the legal rate until disbursed. The successful claimant is entitled to the interest as well as the principal. History: interpleader is a civil procedure developed under equity jurisprudence, though originally it was derived the interpleader form of action at law, which only applied to bailees subject to multiple actions of detinue. However, the action at law became obsolete and relief became available from the Court of Chancery. The Bill of Interpleader traditionally required, the same thing, debt or duty must be the res claimed by all the claimants. All the adverse titles or claims must be dependent or derived from a common source. The stakeholder must not have or claim any interest at the res, the stakeholder must have incurred no independent liability to any claimant, that is he must be perfectly indifferent between them. In 1831 Parliament passed the Interpleader Act, 1 and 2 Will. 4 ch. 58. That authorized the bring a bill of interpleader in the courts of law by sheriffs who have executed on goods or chattels that a third party make a claim to and defendants in actions of assumpsit, debt, detinue or trover who does not claim any interest in the subject matter of the suit but the right to them is claimed or supposed to belong to a third party who has sued or expect to sue for the subject matter of the suit. Has not colluded in any matter with such third party, is ready to bring into court or pay or depose of the subject matter of the action in such manner as the court directs. Parliament enacted the Common Law Procedures Act 1860, 23 and 24 Vict. Ch. 126a Section 12, which allowed a defendant in courts of law to interplead claimants even if title of the claimants to the res have not a common origin, but are adverse to and independent of one another. Formerly a plaintiff had to disavow any claim to the res in order to avail himself of the interpleader remedy, but this requirement has also been relaxed or abolished in most jurisdictions by there being a bill in the nature of interpleader rather than a strict bill of interpleader. A plaintiff may now argue that neither of the claimants has a right to the property at issue. For example, a person dies with a life insurance policy that excludes coverage for suicide. Two people come forward claiming to be the beneficiary named in the policy. The insurance company believes that the deceased committed suicide, but the claimants believe the death was by accident. The insurance company could interplead the two claimants and simultaneously deny the claims. The Supreme Court of the United States ruled in New York Life v. Dunleavy 241 U.S. 518, that for a claimant to be bound by an interpleader the party must be served process in a way that obtains personal jurisdiction. In 1922 the United States Supreme Court in Liberty Oil Company v. Condon Nat. Bank 260 U.S. 235 sustained that a defensive interpleader in an action at law in federal court could be taken under Judicial Code Section 274b added by 38 A Stat A 956 that authorized the interposing of equitable defenses in actions at law. The Federal Interpleader Act of 1917-39 A Stat A 929 was enacted by the 64th United States Congress approved February 22, 1917 to overcome the problem with an interpleader when the claimants live in different states raised in New York Life v. Dunleavy. Federal Interpleader Act of 1917 allowed an insurance company, or fraternal benefit society subject to multiple claims on the same policy to file a suit in equity by a Bill of Interpleader in United States District Courts and providing nationwide service of process. The policy must have a value of at least $500 claimed were claimed or may be claimed by adverse claimants, which is less than the amount in controversy of $3,000 in Judicial Code A Section 48, 1. Then required for general diversity jurisdiction and two or more of the beneficiaries must live in different states. In 1926 it was repealed and replaced by 44 A Stat A 416 approved May 8, 1926, which added to those who can bring suit casualty company and surety company, empowered the court to enjoin claimant from proceeding in any state or other federal court on the same liability, adding provisions as to the proper venue for the interpleader in certain cases but required that there must be actual claims by eliminating the words may claim that were in the 1917 Act. In 1936 the Federal Interpleader Act was again repealed and replaced by the Federal Interpleader Act of 1936, 49 A Stat A 1096, approved January 20, 1936, drafted by Zechariah Chaffee which codified it in as United States Judicial Code A Section 41, 26, and established the modern statutory interpleader allowing suit to be brought by any person, firm, corporation, association or society having custody of money or property or insurance policy or instrument valued at $500 or more which there are two or more adverse claimant, who are citizens of different states, whether or not the claims have common origins, identical, adverse or independent of each other, and allowed it to be an equitable defense in actions at law, Judicial Code A Section 274b. When the United States Judicial Code was enacted into United States Code as positive law in 1948, 62 A Stat A 931 approved June 25, 1948, it was reconstituted as 28 U.S.C. A.A. millisecond 1335, 1397, and 2361. Federal courts have held that because of the deposit of the res with the court an interpleader action is an action to determine the validity of competing claims to identified property that served may be under 28 U.S.C. A.A. millisecond 1655 which authorize other forms of service to obtain in rem jurisdiction over absent defendants. Different types of interpleader in U.S. federal practice. There are two specific types of interpleader actions in the United States federal courts. Statutory interpleader governed by 28 U.S.C. A.A. millisecond 1335, and rule interpleader established by Federal Rules of Civil Procedure 22. Statutory interpleader, 28 U.S.C. A.A. millisecond 1335 allows an individual with a stake which is, or may be, claimed by two or more adverse claimants, to interplead those claimants and bring them into a singular action. Jurisdiction, under 28 U.S.C. A.A. millisecond 2361, a person anywhere within the United States may be served by the stakeholder. Diversity jurisdiction is satisfied as long as there are two claimants of different states. 28 U.S.C. A.A. millisecond 1335, A. 1. For example, if you have three claimants, two of which are residents of Florida, and one from California, diversity would be satisfied. The diversity of the stakeholder, however, is irrelevant to the rule. This is known as minimal diversity and was held to be permissible under Article 3, a Section 2 of the United States Constitution, State Farm Fire and Cas Company v. Tasha 386 U.S. 523, 530, amount in controversy, the stake in the claim must be greater than or equal to $500 in value. 28 U.S.C. A. Millisecond 1335, a. Opposed to the Rule Interpleader requirement of any amount exceeding $75,000 in diversity-based actions. 28 U.S.C. A. Millisecond 1332, b. Venue. The venue for a statutory interpleader is in the judicial district in which one of the claimants resides. 28 U.S.C. A. Millisecond 1397. Deposit. A statutory interpleader action is commenced by the stakeholder who must initially deposit with the court the amount in controversy, or post a specific bond with the court. 28 U.S.C. A. Millisecond 1335, a. 2. The stakeholder may, however, at trial claim they don't owe money to the claimants at all, since the action can be in the nature of interpleader. Such an action may be entertained although the titles or claims of the conflicting claimants do not have a common origin, or are not identical, but are adverse to and independent of one another. 28 U.S.C. A. Millisecond 1335, b. Injunction. Once the statutory interpleader action is commenced, the court may restrict all claimants from starting or continuing any action which would affect the stake, make such injunction permanent, and discharge the stakeholder from liability. 28 U.S.C. A. Millisecond 2361. Such injunction is not governed Federal Rule of Civil Procedure Rule 65. The may claim language added in 1948 codification to Title 28 of the United States Code in the definitions of claim allow interpleader for unliquidated claims, such as multiple claimant to a liability insurance policy injured in an accident before they are reduced to judgment or settled. However, the injunction may only restrain the claimants from suits making claims against the res, not suits to liquidate the claim or against third parties. The procedures for a statutory interpleader action are governed by the Federal Rules of Civil Procedure. Rule 22, b. Rule Interpleader, current as of December 1, 2011, interpleader is also allowed by the Federal Rules of Civil Procedure 22. Rule 22 is known as Rule Interpleader. Rule Interpleader provides a remedy for any person who is, or may be exposed to double or multiple liabilities. The stakeholder may invoke Rule 22 as a plaintiff, or by counterclaiming in an action already started against him by one, or more claimants. There are specific differences between statutory interpleader, and Rule Interpleader. Jurisdiction. Rule Interpleader does not provide a basis for jurisdiction in the United States District Court. There must be an independent basis of jurisdiction under Title 28 of the United States Code, that is diversity jurisdiction. 28 U.S.C. A. Millisecond 1332, a, which requires that the claimants have complete diversity between the stakeholder, and all claimants, but not between the claimants, or federal question jurisdiction. 28 U.S.C. A. Millisecond 1331, that is when a claim is based on federal law, or there is a specific statute authorizing interpleader, that is 38 U.S.C. A. Millisecond 1984 or 49 U.S.C. A. Millisecond 80110, e. Service. There is no nationwide service of process as in a statutory interpleader action. Service must be carried out within the state where the court sits, or according to the long-arm statute of the state, Rule 4, K. 1. Amount in controversy. The amount in controversy must exceed $75,000 if based on diversity jurisdiction meeting the requirements of 28 U.S.C. A. Millisecond 1332, b. Deposit. There is no deposit required to be made with the court for a Rule 22 interpleader action. The stakeholder may claim that they are not liable in whole, or part, to any or all the claimants, Rule 22, a. 1, b. However, for the stakeholder to be discharged he must depart the money or property in the court pursuant to Rule 67. Bankruptcy. In bankruptcy court interpleader under Federal Rules of Civil Procedure 22 may be maintained as an adversary proceeding under Federal Rules of Bankruptcy Procedure 7022. Federal Rules of Civil Procedure 22, a. Grounds for an interpleader action, 1, by a plaintiff. Persons with claims that may expose a plaintiff to double or multiple liability may be joined as defendants and required to interplead. Joinder for interpleader is proper even though, a. the claims of the several claimants, or the titles on which their claims depend, lack a common origin or are adverse and independent rather than identical. Or, b. the plaintiff denies liability in whole or in part to any or all of the claimants. 2. By a defendant. A defendant exposed to similar liability may seek interpleader through a cross-claim or counterclaim. b. Relation to other rules and statutes. This rule supplements a euro, and does not limit or a euro the joinder of parties allowed by Rule 20. The remedy this rule provides is in addition to a euro, and does not supersede or limit a euro the remedy provided by 28 U.S.C. A.A. millisecond 1335, 1397, and 2361. An action under those statutes must be conducted under these rules. Interpleader in U.S. state practice. The Uniform Commercial Code A Section 7-603 adopted in all 50 of the states of the United States provides that a bailee when more than one person claims title to or possession of the goods under document of title may bring an interpleader as an original action or as a defense to a suit for non-delivery. In Louisiana, interpleader is called concursus. In most states there are statutes or court rules that provide for interpleader similar to the federal rules. Interpleader in England and Wales. Interpleader in England and Wales was until April 6, 2014 governed by RSC Order 17 in the High Court and CCR Order 33 the County Court. In the High Court an interpleader may be brought by, a person is under a liability in respect of a debt or in respect of any money, goods or chattels and he is, or expects to be, sued for in respect of that debt or money or those goods or chattels by two or more persons making adverse claims thereto. Or, a sheriff or a person expected to be sued by two or more persons as claims made to any money, goods, or chattels taken or intended to be taken by a sheriff in execution under any process, or to the proceeds or value of any such goods or chattels, by a person other than the person against whom the process is issued. In the county court it may be brought in case of, or a person making a claim to or in respect of goods seized in execution of the county court or the proceeds or value thereof. A person is under a liability in respect of a debt or any money or goods and he is, or expects to be, sued for in respect of the debt, money or goods by two or more persons making adverse claims thereto. In cases where the A person subject to multiple claims the applicant must show he claims no interest in the subject matter in dispute other than for charges or costs, does not collude with any of the claimants to that subject matter, and is willing to pay or transfer that subject matter into court or to dispose of it as the court may direct. On April 6, 2014 Civil Procedure Rules Parts 85 and 86 came into force and RSC Order 17 and CCR Order 33 were omitted. Civil Procedure Rules Parts 85 and 86 govern interpleader procedures in both the High Court and the County Court, though they do not mention the term interpleader. The title of CPR Part 85 is Claims on Controlled Goods and Executed Goods. This part applies when a person makes a claim to goods taken by an enforcement officer under a writ of execution belong to that person, not the debtor. A person makes a claim to goods seized by an enforcement agent under warrant of control or writ of control belong to that person, not the debtor. The debtor claims goods seized by under warrant of control, writ of control or writ of execution and are exempt goods. The title of CPR Part 86 is Stakeholder Claims and Applications. Part 86 is applicable when a person is under a liability in respect of a debt or in respect of any money, goods or chattels, and competing claims are made or expected to be made against that person in respect of that debt or money or for those goods or chattels by two or more persons. A stakeholder may make an application to the court for a direction as to whom the stakeholder should pay a debt or money, or give any goods or chattels. The application must be made to the court in which an existing claim is pending against the stakeholder, or, if no claim is pending, to the court in which the stakeholder might be sued. The application must contain a witness statement stating that the stakeholder claims no interest in the subject matter in dispute other than for charges or costs, does not collude with any of the claimants to that subject matter, and is willing to pay or transfer that subject matter into court or to dispose of it as the court may direct. See also, multiple appoinding, a similar form of action in Scots law, references.